said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
And Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life. I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question.
Yeah, LTL true crime, we going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi. LTL true crime, unraveling the web of evil. No stone left unturned, we dive into the prime. Yeah, we digging up the dirt, bringing justice to the crime. LTL true crime, unveiling dark realities every time. Yeah, LTL true crime, we going deep in the dark. Peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi. LTL true crime, I go. We don't get live in the shine, but then I'm not talking about it, that's so. Look at the place in the world. No can to it, your lie. No to it, your love. We better hit that. You'll be hit out of your die. Better than looking the boats. I pick real true crime. I'm done with dark realities every time. This is I pick real true crime. I'm done with dark realities every time. Yeah, LTL true crime. We going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi. LTL true crime. We going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi.
Welcome in, everybody. Welcome back to LTL True Crime Live. We are here on this Thursday afternoon. It's a very important day in the Karen Reed case. And, you know, this is just a complete waste of resources and time. We have an innocent woman that's been dragged into court, that has been framed of all these charges, and it needs to stop. It needs to end. We know the truth. We know what went on in that house that night in 34 Fairview. We know the cover-up, and I'm feeling the end is coming soon. I'm feeling the end is coming soon. And so hopefully we will get some answers to that today. If anybody's wondering, Karen will not be in court today. It will be via Zoom. I have the court TV stream that I'm going to bring up. I was going to log into the Zoom call, but I don't want to mess up and cause any type of disruption. So we'll watch the court TV stream. And if it doesn't seem like that's going to be a great stream, we'll find something. You know, we'll find some of this. But the most important thing is that we're all here today. We're all here to support Karen, Aiden, the Canton 9, and get justice for John O'Keefe. This just needs to end. It needs to end. It's complete time and resources. This poor young lady has had her life literally on hold for almost 2.5 years. It needs to stop. It needs to end. We need to have the correct people sitting in the seat where Karen Reed is sitting. So hopefully this will end soon. And I do feel in my heart of hearts this is going to end soon. But let's do this. We have a little bit of the show that we're going to get into before the hearing starts. Like I said, Karen will not be in court today. Jackson and Little could not be there. They have trial today. So they're back at their respective places for trial. and I believe they will be on via Zoom. And of course, Yannetti will be there as well, and Karen. So let's do this. I have an article here that just got posted a couple of hours ago from Boston 25. And we'll read this really quick. And then I have a little excerpt from Ted Daniels. So hearing set for Thursday, and Karen Reed, a woman accused of killing Boston police officer boyfriend. Just hang on one second. I just got to do a little housekeeping here. Great. That should do it. Okay. So Canton, Mass. 25 investigates, including a hearing scheduled Thursday in the case against Karen Reed, a woman accused of killing a Boston police officer boyfriend in Canton. The hearing is set for 3 p.m. Thursday on Zoom. The judge is set to hear several issues on Thursday's docket, including a request by the Norfolk District Attorney's Office for notes and recordings from the interview Reed did with Boston Magazine last year. The Norfolk District Attorney's Office also wants to keep the letters exchanged with the federal authorities confidential. 25 Investigates was the first to report on the one time on those letters in early December. Thank you, Ted Daniels. We've since learned from the court filings that 8 such letters exist in a deal with the federal probe and deal with the federal probe of Reed's case. Sources tell us that the federal officials are or were looking at the arrest and prosecution of Reed by local and state enforcement. The status of the federal probe is a tightly guarded secret. On Friday, 25 Investigates reports federal officers do not oppose the release of the letters. Great. We need that. That's what we need. That's all good stuff. All positive stuff here for Karen Reed. All right, let's go to Ted.
Investigators will be covering a hearing scheduled for tomorrow in the case against Karen Reed. She's the woman charged with killing her Boston police officer boyfriend in Canton. Investigative reporter Ted Daniel has been on the case for nearly 2 years now. And as Ted explains, this time the hearing will take place on Zoom and not in a courtroom.
There are a couple of issues on the docket. One is a request from the Norfolk District Attorney's Office to keep the letters it exchanged with federal authorities confidential. 25 Investigates was the first to report on one of those letters in early December. We've since learned from court filings that there are 8. The communications deal with the federal probe of the Karen Reed case that we've been telling you about. Sources tell us the feds are, or at least were, looking at the arrest and prosecution of Reed by local and state law enforcement. The status of that federal probe is a tightly guarded secret. On Friday, 25 Investigates reported the feds do not oppose the release of the letters. In addition, the judge will hear a separate request by the DA's office for notes and recordings from an interview Karen Reed did with Boston Magazine last year. We plan to cover the hearing. It's scheduled for 3 p.m. Thursday, and it's going to be on Zoom. For 25 Investigates, I'm Ted Daniel.
Perfect. So that's where we're at there. So we're caught up to speed, and we have about another 30 minutes. All right. So what we're going to do here is everybody's kind of been begging for more Turtle Boy, and this is the best that I can do right now. But I thought this was a fantastic video. We're going to go back and look at his 50 red flags. And this is going to be a nice update for people if they're just coming into the Karen Reed case. And again, it's been my style. I go back and I review and go over and over again. And people have been super happy with that. The stream that I did with Tom the other night, we heard so many new things in those court hearings. And that was the May 25th hearing. And we're like, what? Rewind that. I haven't heard that before. So again, you know, we're so far out. You tend to forget things. And going back and going over this repetitively, you see and hear new things in all of this. So that's why I do this. So let's take up some time here. We're going to play Turtle Boy. I know everybody's going to be super excited about seeing this because we're going to be able to see him here. And this is his 50 red flags in the Karen Reed case that you just can't ignore. So that takes us right up to the hearing. All right, here we go.
We've done nearly 70 blogs and counting on the Karen Reed murder case. And although many of you have read every story we published, it can be a little difficult to keep up as new information is being published. To understand just how ridiculous this attempting lynching of an innocent woman is, I thought it would be helpful to put together a list of the top 50 things you must ignore in order to arrive at the conclusion that Karen Reed is guilty. If you're unfamiliar with the Karen Reed case, I recommend you watch our feature video, Framed: Commonwealth versus Karen Reed, This will give you a full and comprehensive background to this ongoing story. The link can be found in the description below.
So number 50, Michael Proctor interviewed Jen and Matt McCabe and Brian and Nicole Albert together. This image right here was taken at 9 a.m. on the day John O'Keefe was done. 3 hours earlier, his body was found on that lawn. And that's Jen McCabe's car in the driveway. And there's not much snow there. Well, 2.5 hours later at 11:30, Michael Proctor interviewed Jen and Matt McCabe and Brian Albert, but he didn't interview them here. Why wouldn't he interview them here? Because there was just a murder there. And they all know that, so they can't be in there. So they need to get out of there. So he gives them time. What are they doing in there? They're getting their story straight. Of course they are. And then they're going across town, and they're going to have an interview over there, the friends and family meeting. Michael Proctor doesn't.
Oh, by the way, Tom and I are going to do another show on Sunday, another Looking Back series, and we'll play. Was it May, June? There was the hearing in July, so we're going to go through that and get you all caught up on that too. So I'm going to have Tommy over here on Sunday night. Friday night, I'm going to have tomorrow night. Wow, it's going quick. Tomorrow night, I'm going to have Melanie Little on the panel. Do this. If you have any questions for Melanie Little regarding the Karen Reed case, please email me, letstalklivepodcast@gmail.com, and I will select some questions out of that to ask her. I did get permission from her to go over the Coffindaffer interview. I cannot wait to go through that. You know, we'll keep it classy, of course. I just kind of wanted to QB over this and just see, you know, her thoughts and what she was thinking at that time. I think it's going to be a great segment, and I think you'll really enjoy that. And then I think I'm going to be back on Turtle Boy's channel on Saturday night doing another host special. We're still working out the details and all of that. So let's not take too much more time here and play through this.
Record anything, and just he knows them all.
Yes,
he's been friends with all of them, and I'm sure it was pretty informal. Second,
Tom did kill a footage.
There was no interviews conducted by Michael Proctor at on video or at a police station. Not one. Not Karen Reed.
And please, if you find it in your heart today, and again, I know I'm stopping a lot, but I just have a lot to get out. I'm super nervous today. I have a lot of emotions. I'm nervous. I'm excited. I'm probably going all through the things that you're all going through as well. You know, we want more information. We want to know. If you can find in your heart today, I have Karen Reed's defense link pinned to the top of the chat. If you can find it in your heart today to donate, please do. I got up this morning. I donated another $100 to her defense fund. If you can help her out today, she needs it more than ever. So please, if you find it in your heart, and you can, through the means of, please donate today.
Not Jen McCabe, not Brian Albert. All of these reports were interviews. Not a single one of them is recorded. So everything you're reading about what witnesses said is the testimony of Michael Proctor, who we know is a liar and an unethical, corrupt cop. So you can't trust anything that he says. Remember the 3-point turn. How do we know Karen Reed did a 3-point turn? She denies it. Jen McCabe and Matt McCabe deny it. Well, because Michael Proctor said that she said it. That's literally all it is. So there's that. Number 48. No one besides Karen Reed was ever considered or treated as a suspect, despite the fact that she has no criminal record, no history of violence, and is a well-respected member of the community. Those things matter during murder investigations. Your criminal background matters. And she was the only one who was ever considered it, despite the condition of his body, despite a serious lack of evidence, despite no taillights being found at the scene, nothing. She was the only one who was ever treated as a suspect in this. They picked their target early on, and they worked backwards from there. 47. The Commonwealth story is that a vehicle going 5 miles an hour in reverse killed a 6'2", 217-pound man, causing multiple skull fractures and lacerations to his arm, despite the fact that he landed on grass and snow. 46. There was never an accident reconstruction report that ever took place. Every time somebody dies in an automobile accident, the police do a accident reconstruction report. Nothing like that has ever happened in this case, ever. And you just have to ignore that. in order to believe that Karen Reed did this. And you have to think that's normal. Because, of course, if you did an accident reconstruction, you would notice how absurd it is to believe that she killed him going however many miles an hour in reverse. And that
62 feet, 24.2 miles an hour. And remember, 62 feet now is off the table, right? So it went from the 3-point turn, 62 feet, 24.2. We take the 62 feet off. Now it's just 24.2. I have no idea what the Commonwealth's fucking narrative. And I talked about this before. What they like to do is, as things get debunked, they like to take those puzzle pieces and switch them around as much as they can to make it fix, to make the puzzle complete. And it's just not going to work because we know the truth. We know the truth.
She assumed that he was dead and felt comfortable just abandoning him there. 45. John O'Keefe's body had to have been struck with enough force to have flown 12 feet in the air because he landed 12 feet from the curb. Number 44. You have to ignore the fact that the Commonwealth has not even attempted to come up with the theory for how John O'Keefe died.
Tommy,
That's a big one.
Buddy.
They never attempted to explain how he died or how he got lacerations on his arm. Every murder case has a theory. The prosecution has no theory. Listen to this.
The damages to the right rear corner panel of the defendant's vehicle. Embedded within the bumper to that vehicle is pieces of cocktails. The victim, Mr. O'Keefe, is last observed on surveillance video,
Constantly
external
changing.
surveillance video from the waterfall establishment that he left just prior to going to 34 Fairview, with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
This is the first I've heard of the Commonwealth's new position after, 15, 16 months, that somehow John O'Keefe was stabbed or cut up with a broken cocktail glass, which would produce these injuries. It makes absolutely no sense. It just doesn't pass the safety test. These are not from a cocktail glass. Who did that to him? Is there a new theory that Karen Reed got out of the car, broke a cocktail glass, then wielded an edge of that cocktail glass and cut up John's arm? Then John stood there.
It's the most impossible theory.
Slams it in reverse, then hits him with the car.
Yeah,
with her tail light in the back of the head.
It's like, is that what happened?
That's what they want you to think. And then I'm just going to drive over them. It's the most ridiculous fucking theory I've ever heard.
Oh, no, because they haven't said a theory yet. They haven't explained it yet.
can't.
It's just like, well, look at him. He's dead, and she did that. So just ignore all this logic and thought and just ignore it. Okay, number 43, you have to ignore the fact that no one interviewed
she's great.
the man who plowed 34 Fairview road that night to see if the body was lying in the snow. You have to ignore that because a plow came through there multiple times during that night. They were never interviewed because they would have seen a body lying there. They would have at least been asked, "Did you see a body, sir?" But they didn't. And
Tom, I've proved it. Tom, I've proved it. I've shown pictures of how you would line up in line with the body of the taillight. It would be soft target here on your chest. Soft target here on your chest, Tom. You know this. You know, we all know it. We know what's going on here.
Of course, they haven't even pursued this. You have to ignore that the Commonwealth is withholding several pieces of evidence, including DNA from John's body that exculpates Karen Reed, which they have been ordered by the court several times to give to the defense. Number 41, if Karen Reed killed John O'Keefe, you have to ignore the fact that she knew that the angry voicemail she left him, in which she said, I hate you, John, that would be used against her as evidence. You just have to ignore that. That they want us to believe that this woman killed him and is like, you know what I'm going to do? I'm going to make myself look more guilty by leaving an angry voicemail. No, you know what a killer does? They leave like a message that's like, I love you so much, John. I would never do anything bad to you. Yeah. Number 40, you have to ignore the fact that every single person that claims that she said that, item is related to the McCabe's or the Alberts, and that includes the Canton Fire Department. 39, to ignore that no one saw or heard a man being hit with such tremendous force that it knocked him to the ground, nor did anyone
If you're just coming in and you're just new here, what we're doing here is 50 red flags pertaining to the Karen Reed case, and then this will take us right into today's hearing. So hang out with here. We're playing a video from Turtle Boy Live's channel. If you don't know, he's an independent award-winning journalist, and he's been covering the Karen Reed case a few months longer, probably a little bit longer than I have. And him and I have built a good relationships together, and we're playing some of his videos here. And it's a good educational video for a lot of people that are new into just catching up on this case.
Hear him calling for help. House full of people. Not a single person heard that thud, boom, of a man being hit with such force or the screeching of a tire, of him screaming out in agony. Ryan Nagel was right there. Number 38, you have to ignore that John O'Keefe's body had no bruising, no cuts, no broken bones on his abdomen, legs, midsection, or left arm, despite the fact that his midsection, his hips, his stomach, that area of his body, his thighs.
So just to let everybody know, BMW lady is in the courtroom today, is in the courtroom. So if she has any updates, she said she'll let us know in the chat. And of course, we'll be listening.
That would have been the part hit by Karen Reed's bumper if he was standing up. But instead, he's unscathed there. The only damages to this man's body are the skull fractures to his head, the eyes popping out, the laceration in the back of his head, and the 7 or 8 parallel cuts on his arm. 37, you have to ignore that Jen McCabe claims to have not seen a 217-pound body laying in plain view, illuminated by snow and obstructed by nothing at 6:03 a.m. while riding in the front seat of a car, specifically looking for a body. We went and
let's just put it this way. You're in a room with good company. You're in a room with good company today. You're going to get a lot of education in here. You're in a room with a good
created
company.
The scene.
Absolutely.
That's what they would have seen, except it would have been more illuminated with the 1 or 2 inches of snow. You have to ignore number 36, that Jen McCabe, Matt McCabe,
You're in the
Julie
right
Nagel,
room
Sarah
today,
Levinson,
Aileen.
Colin Albert, whoever drove Colin Albert home, Brian Higgins, Brian Albert Jr., and whoever else was inside 34 Fairview Road and left that night somehow did not see John O'Keefe's body on the front lawn, despite less than 2 inches of snow falling. Oh, but it's a conspiracy, Turtle Boy. Surely, if one of them saw the body, someone's going to say something. Well, maybe the body wasn't there yet. Yeah, you're onto something. You're so close. You have to ignore that a pool owned by Tim Albert at the home where all the Alberts gather was filled in for no apparent reason 1 week after the Alberts were named in court for the first time as potential suspects by Karen Reed's defense attorneys. Number 34, you have to ignore that Jen McCabe Googled how long to die in cold at 2:27 a.m., despite telling police that she believed John O'Keefe had gone home with Karen Reed and had never been inside there. You know what the prosecution has said? Is that, oh, well, she was on another browser for Ozone Basketball. Well, guess what else I found out today about that? As an emailer points out, have you actually checked out the Ozone Basketball website? And the answer is no, I have not. I've never checked out the Ozone Basketball website. And they go on to say that the Ozone website does not have scores or schedules on the site. And I went and verified that. They don't. Additionally, Ozone Basketball does not have winter AAU. Therefore, there were
what was it? 30 nanoseconds or some like 3 nanoseconds that to shut down that web page with the web page behind it, right? When Jen was clicking it. Is that what they said? It was queued up. And then they're saying that it lagged. That's why it took so long. But the tab was up. The tab was up. No, I will not. I'm going to go full screen and let everybody listen. Yeah, it was a millisecond. I will not be commentating. No, it's your stream. We're going to go open live and I will just pull chat up.
Would be no score to check for Jen McCabe about her kids.
That's right.
Number 33. You have to Google that Jen McCabe Googled how long to die in cold again at 6:24 with the exact same spelling mistake, HOS, at 6 that she did at 2:27, the exact same one. And that she also Googled it at 6:23 spelled differently, wasn't happy with the way that came up, and so Googled it the wrong way, a different way. You have to believe that that's normal. Number 32. You have to ignore that Jen McCabe deleted all of her calls, texts, and Google searches before and after finding John O'Keefe's body. That's nothing else. She called people all day. She didn't delete any of those, just the ones right before and after finding the body. She also deleted a screenshot of Brian Albert's phone number and a Google search for how long to digest food, which could be used by a pathologist to determine time of death. You just have to ignore it all. Number 31, you have to ignore that Jen McCabe called John O'Keefe 6 times in a panic between 12:40 and 12:50 a.m., despite having no reason to believe that anything bad had happened to him, and despite claiming that she saw Karen Reed drive away at 12:45. So wouldn't she have assumed that he just went home? Isn't that what she told the police? So why is she calling him like he's missing already at between 12:40 and 12:50. Next, you have to ignore that the Commonwealth claims that Jen McCabe never Googled how long to die in cold at 2:27 a.m., but then filed a motion to cancel an evidentiary hearing where Adam Lally could have cross-examined forensic expert Richard Green, who claimed that she made and then deleted that search, as well as the other incriminating calls and text messages. You just have to ignore that. I mean, that's wild. The Commonwealth is stating, no, those Google searches that your expert pointed out, those aren't real. And instead of proving it by cross-examining him, we're just going to cancel the hearing altogether. 29, you have to ignore that Trooper Nicholas Guarino's extraction report intentionally left out all of Jen McCabe's incriminating Google searches that directly inculpates her. You just have to ignore that. The information that they gave the defense was missing all of this shit. And you have to think that's normal. Okay. You have to ignore that the Commonwealth's only explanation for her 227 Google search was that it never happened because she was on Ozone Basketball checking scores, which we now know couldn't happen because they don't have scores on there. Number 27, you have to ignore that Colin Albert called Tom Beatty's daughter, Erin, at 12:33 a.m. to ask for a ride home. You just have to ignore that right around the time when his phone stops moving, boom, calls Erin Beatty. And you have to think that's normal. Number 26, that Jen McCabe called Tom Beatty 3 times between 5:30 a.m. and 6 a.m., despite having no reason to call him, since Beatty was not at 34 Fairview Road and would have no idea about John O'Keefe's whereabouts. You have to ignore the only evidence tying Karen Reed to the crime scene are pieces of taillight found by the search team 12 hours after discovering O'Keefe's body. But then you have to ignore that there is Ring camera footage showing her.
So she's pulling out in the black SUV.
Yeah, if you haven't seen this video, I've done many enhancement of this video to prove that Karen hit John O'Keefe's SUV pulling out that night. You can, if you're a first timer over here, you can go to my video section on my main page and watch all those enhanced videos. It's really fascinating. So check this out.
And that's the victim's SUV parked. And the defense says that she makes contact, hits the victim's SUV right there, damaging that back right passenger side taillight. Just
for the moderators, let me just clear this up really quick with the moderators. Let's slow the pacing on the chat, on the exclamation point drops. I want to slow that in the chat. We don't need to do them as frequent. Nightbot is set to do it regularly, so it's on a timer. Just slow that stuff down because it kind of spams the chat, and that's why I cleaned a lot of that up, a lot of the functions out of it to try to not be so distractful. If I need to cut Nightbot down, I will. And I've been trying to slow it back a little bit because it has been dropping too much. So the exclamation points, let's stop those today. All right. Because we have the Karen's link at the top. Again, if anybody wants to donate to that, I encourage them to. Please. It's Karen's day. And also Nightbot will regularly drop them. So let's kind of peel back a little bit on that today.
And they also claim you can see, the victim's SUV move, indicating that there was a collision. And then as she pulls away, they say that you can tell.
Oh, part of her taillight's missing. There it is. There's a bulb missing there. So pretend like you didn't see that video. I didn't see nothing there. Just ignore it because that's what Adam Lally's doing, just ignoring that. Number 24, you have to ignore that the Canton police reported finding no taillight evidence at the scene of the crime at 6 a.m. Then you have to ignore number 23, that 12 hours later, state police under the direction of Michael Proctor found more taillight fragments. The pieces of taillight are not found under the snow. They're found on top of the snow, which is now accumulated over a foot in the 12 hours since then. How the hell does a piece of taillight end up on top of the snow? What? And a shoe. Somehow the Canton Police Department missed a shoe and a hat. They missed it all. None of that was out there, remarkably, but the CERT team found it after a foot of snow had fallen.
Yeah.
Very impressive. Number 22, that Michael Proctor never disclosed that he was a close family friend of the Albert and McCabe families. You have to ignore that 88 Lally lied in court when he said that this image of Proctor with McCabe's daughters was not actually a picture of their daughters. Those are Jen McCabe's kids. The two kids in the back are Jen McCabe's kids. Adam Lally said, no, the girl in the foreground is not her kid. Okay, we know that's not her kid. The two girls in the back are. We know that because there's pictures of them all over Jen McCabe's
Appreciate it.
Those are her kids. It's undeniable. But you just have to ignore the fact that the Commonwealth is saying that he's never met the McCabe's. Number 21, you have to ignore the fact that alarm.com footage from Karen Reed's parents' house at 4:12 shows Proctor lied when he said the car was towed at 5:30 p.m.
What's up, Mazza?
Which
Good to
gave
see you.
him 1 hour
Thanks
and
for sharing my
18
stuff
minutes
on
of
Twitter. I appreciate it. Thank you.
being unaccounted for.
We got about another 8 minutes, 8 or 9 minutes. We got about 9 minutes until the hearing starts. I'll pull away from this and we'll go to the hearing itself. And then I will sit back and let everybody listen because I need to listen as well. Probably go full screen and then just pull up the chats as they go. I'll make that decision when it starts. But I'm going to try to not talk. I know this is very important to everybody today.
Or with the car. You then have to ignore that taillight fragments were found on top of over a foot of snow at 34 Fairview Road at 5:45. You then have to ignore that Michael Proctor knew that CERT team would be there by 5:45, and by saying that the car was towed at 5:30 p.m., that would make it impossible for him to physically have planted evidence by 5:45, since Canton is more than 15 minutes away from Dighton. Number 20, you then have to ignore that Dighton police records show that Proctor called for a tow from Karen Reed's parents' house at 2:30 p.m., despite having not seen the broken taillight and despite claiming that he didn't get there until 4:30. You then have to ignore that Michael Proctor misspelled the names of 5 witnesses wrong. All of them
Cheryl, I
were
wouldn't miss it
in
for the world.
34 Fairview Road that night, including the homeowner's daughter, a nurse, the daughter of the town administrator, and Brian Albert Jr.'s girlfriend. That all of them had their names spelled wrong in the report. Number 18, you have to ignore that despite being material witnesses who drove past and were just feet away from John O'Keefe's body, like when they left at 2:30, they would have driven going south on Fairview and his body would have been sitting 12 feet away from them. And you would have to ignore the fact that all 4 people in.
Let me just get these in. Megan 499, thank you so much. Says thank you for dedicating so much time to this case and your efforts to keep the message out. Yes, of course. You know, we all had to step up. You know, in the absence of Turtle Boy, you know, we care about him. We care about Aiden. We care about Karen. We care about John. We care about the Canton 9. And, you know, it was just pushing forward and holding that torch right now and keeping that flame flickering. We cannot let this flame burn out. We can't. And I stepped forward and just tried to get to some of the closest people that are to him. And I said, what can I do to help? And he said, keep streaming, keep talking, keep letting people know about the Free Karen Reed movement. Keep letting people know that Karen is innocent. She's innocent. And I said, I can do that. I can do that. And, you know, all of the streamers, and I put a tweet out today, and let me show you that tweet really quick. And then it should be just in time to cut away from, to go to the court hearing. But I put a tweet out today, just letting everybody know, look, you know, if you don't like my content or whatever, there's other channels that are covering this. Huge support for Karen Reed today. Here's a list of some of the YouTube channels I'd like to direct your attention to. These creators and mainstream media are covering the Karen Reed case in their own unique ways. Make sure to give them a like, share, and subscribe. Dr. Turtleboy, that's obviously Turtleboy, he's the leader. Glare has been doing this. We have now Melanie Little that's in this. She'll be joining me tomorrow on my channel. Then we have Tom that's in the chat. I directed that, put his tag out there. Dave from Unsafe Spaces has been doing some stuff. I haven't really seen him do much stuff lately. and of course, Ted Daniel. And, you know, and I just said, as a team, we accomplished more. And, you know, Karen Reed was framed, you know, so, you know, I just wanted to put that out there for everybody and direct attention to everybody. You know, we're all doing our part. It takes a team. It's not just one person. And I commend the people that stood out there today. It was cold. They were out there for the Canton 9 today. They did their own peaceful protest in their only way. I had some photos that were shared with me really quick. I'm going to cut away from Turtle Boy, and I just want to share these photos really quick before we go into the hearing itself. But I want to appreciate Paul for getting these over to me. And I thought this was really cool, and I'll share these with everybody. If you know, look, there's a lot of people that pay attention to this case, and they can't physically be here because they may live far away. But it was nice that Paul sent these in, and that was cool. You know, freedom of speech is not a crime. We had this other one from out there from Framed. And then this is a great shot here with the Canton 9 attorney and everybody out there with their support. So again, you know, this is it. It's powers is always in numbers. Power is always in numbers. It's completely true. And we can't back down. That's the thing. We cannot back down from this. And we need to keep stopping, because this could be you. This could be someone in your family that is in this position, and you have to fight. You have to fight for it. And there's nothing wrong what we're doing. This is a First Amendment choice to stand up and speak. Listen, mainstream media puts articles out daily that trash people, and you have tabloids that trash people. Why is it that we're out here doing something positive, and the media and these fucking trolls on Twitter and YouTube want to trash us? We're out here fighting for someone's life, for you know, that could go to jail for the rest of her life. And, you know, her boyfriend, now deceased, which is horrible, does not have justice yet. And, you know, there's nothing wrong what we're doing. There's nothing wrong. You need to stand up and speak. All right, let's go into the hearing. I'll cue that up, and we'll wait here for the Court TV feed to come in. And once it starts, I'm going to sit back and let Court TV run, and let you know, it do its thing. So I appreciate everybody being here today. If you haven't already, please make sure to subscribe to the channel. We're here to support Karen Reed today. We're all doing our part. It takes a team. It's not one person. I can't wait until Aiden gets back in this, and I'm sure he's got a lot that he's going to say and report, and we need him back out here as well. So we need to support Aiden as well. But today is Karen's day, and you know, we're all wanting some good news here pretty soon. I feel we're going to get some good news soon. I do, in my heart of heart. Yeah, I mean, if someone can find me another direct feed, I have the Boston 25 feed. I'm going to look up here and see if they're streaming it. I was going to try to get onto the Zoom call, but I don't want to be that asshole that unmutes the mic and causes a problem. So, you know, that's what we're doing. So I have a feeling they're not going to cut away. I think this is going to be just a direct feed. And if one of my moderators can find a better feed, maybe Boston 5 or Boston 25, I'll play that. But I didn't want to be that guy that screws up the Zoom call and causes a distraction. This is just a safer way of doing it, and will maintain. I don't know. But I also have the Boston 25 news up too. They're probably going to stream this too. So if we have a problem, I'll jump over there. I don't see anything yet. So let me go to their YouTube page, but we'll wait here on Court TV, and you know, this is what happens. Let's see. Oh, thank you, Daniel. Thank you. I appreciate it. Jenny says McAlberts are at the courthouse. I don't see any other live streams right now, but we'll wait. Yeah, I was going to tap into the Zoom, but I just don't want to be a distraction. I don't want to, I just didn't want to go through all that and stress myself out. And then, it's unmuted and it causes a big problem. We'll deal with here. If not, if this feed's not good, I'll find something else. But I think that Core TV is just going to stream the, it is, it's a Zoom hearing. So this most likely is just going to be audio today. Because it's still an open court. It's still in an open court. Here we go. The audio is up, so that's not me. So we're just waiting. This is probably the feed that we're going to get. And we will wait. Welcome in, everybody. Welcome to LTL True Crime. We're waiting for the live court audio of Karen Reed's court hearing today. We'll talk about some notes that were taken from an article and also the federal letters today. I don't see any other feeds. I don't see Boston 25 up. Let's see. Nothing on Boston 25. But we will wait. Yeah, well, you know what? But we're hanging out on LTL today. That's what we're doing. We're hanging out. We're local here. We're in the local area. We're the locals. Channel 10. Let me see what I got. Is it on the YouTube? Oh, you're welcome. Let's see. We should be starting soon, about another 5 or 6 minutes. By this time, I probably could have just logged into the Zoom call. But we'll hang out here. So I just got an update. The court, well, I don't know. Well, Jim hasn't started yet. So Zoom hosts the that's what we're waiting on right now, folks. And I'm getting the Zoom particulars because everybody's going to freak out that I'm using Court TV. So I'm working on it. So it's not my delay. This is the delay in the court. It's Jim. Blame it on Jim. Jim. I gotta get that. Jim. Well, let's entertain everybody right now.
It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck.
Yeah, Court TV is going to be fine. I'm already going to tell you, it's going to be a direct stream. They're not going to do commercials. Jim. All right, let's see. Oh, thank you, Probot. I appreciate it. Yeah, we're waiting for the court. I don't know. He's not an officer. The court clerk to dial in. I have people giving me updates. I'm looking at my phone right now. Jim hasn't started. Jim. Denise says I have in the background. She thought I was glitching. Hey, we're about 6 subscribers away from to getting to 15,000. That's pretty boss. And at 15,000, we're gonna do a celebration. I'm gonna do a nice giveaway to someone. Court TV will take commercial breaks for TV. I don't think it's gonna be a commercial break here. This is gonna be a direct live stream. If I'm wrong, then I'm wrong. So I don't know. I'm trying to do my best, folks. I didn't want to log into the Zoom. I didn't want to screw anything up. Oh, look at that. We're at 15,000. We just hit 15,000 subscribers. Wow, that's pretty cool. Thank you all so much. Wow, what an honor. I would never have thought I would have been here. I would have never thought I would have been here. Back in March, I would have never thought I would have been here. So thank you. I appreciate it. And, you know, this is not the only case that I cover. I cover many, many cases, over almost 900 videos on my channel, 3 years working at YouTube. Working at this, it's not easy. I work, for all the new subscribers in here, I work a full-time job, and I do this on the side. I'm very passionate about this. I want to do this for the rest of my life. And we're getting there. We're working towards it. Carrie, thank you so much for the 10 gifts. I saw a couple super chats come in. I'm sorry. Cheryl with the $9.99. Thank you. We have our great guys, Ezekiel, John, Roll Tape, always in the chat. I love it. Thanks for the 2. And Carrie with the 10. Thank you. If anybody doesn't know, Carrie is my top mod here on the channel, and has been a huge supporter of this channel for a very, very long time. And I do appreciate it. But wow, I would have never thought. I really would have never thought. It's been a very amazing journey. And my life has been really, over the last 3 months, has changed a lot. And I've met some really fantastic, supportive people. And it's been an honor to meet those people, and it's been an honor to stand side by side with them, to go out to these court hearings and getting to hear their story, how they got involved, what drives them. And thank you. You know, as much praise as I get, there's a lot of shit that I get too. And I'm going to keep pushing on, because I have an extreme passion about this, and I want to keep doing it. And I'm not here to take away from anybody. I want everybody to watch everybody. I want everybody to watch Tom. I want everybody to watch The Glare. I want everybody to watch Turtle Boy, the King on the Mountain. I want everybody to go over and check out Melanie Little. You know, this whole thing about, you know, I can't stream now, I stream over them. We all watch the same channels. We all watch the same channels. And collectively, at the end of the day, if we all work together, the common point is made in all of this, that Karen Read is innocent. And every new person that we can bring into this movement and educate them about that, so they tell someone, and then that person tells someone, and so on and so on and so on, it grows this movement. And that's what this is all about. And again, you know, my story was I met Turtle Boy twice, once at a court hearing, and he came graciously on my stream once. And he is in a terrible predicament right now, where he is in jail. And I went to his people and I said, what can we do? What can we do to help? Because we don't want the fire to burn out. And I just wanted to help carry on the movement, just like Tom, the Glare. Melanie Little's now getting involved in it. And it's fucking awesome. It's awesome, because collectively we all work together. You know, we all achieve more as we work in a team. Shara, thank you so much. I think I was your 15,000 subscriber. Thank you. I appreciate it. Let me just do this. Patty, thank you so much for the 4. I appreciate it. We're still waiting on the feed here. I haven't heard anything. And Brian, thanks for the 5. I appreciate it. Lori, thanks for the 5. I appreciate it. They are live and in session. All right, well, we're waiting here. I'll refresh the feed. Still nothing from Court TV. I'm doing my best, folks. We'll get there. Here we go. Should. And they might be on a little delay. Keep that in mind as well, too. Carrie, thank you for the $19.99. I appreciate it. Now I'm getting frustrated now. I'm like stressing out. Where is this feed? Court is going to conveniently mess up the Zoom. The Zoom started. It's on Canton Community TV. All right, we're going to go there. Fuck this. I'm getting stressed out. Where is it in the Canton Community stream? It's way too much going on. Can someone email me the link? Someone said the Canton Community stream, because I'm getting stressed now. I see all the super chats. Thank you all so much. I'm just trying to find the stream. I'm getting irritated. Please, if someone can just email me the link from Canton Community. I can't find it right now. I have my phone is going off. Everything is super crazy right now. And I can't answer everybody. I'm sorry. And I all right, here we go. What is this shit? I don't care about fucking Joe Biden. What are we doing? What are we watching? What are we watching right now? What the fuck is this?
What flavor did you order?
What? What the fuck are we doing?
M&M milkshake.
Who cares?
Triple thick, man. Yeah. Cheers, Mr. President.
as it
I
pertains
got it.
to any of these materials.
What the fuck was
pursuant
that?
to statutory, pursuant to the statute, pursuant to the case law's interpretation of that statute, as it pertains to any item or matter pending or pertaining to a grand jury. So the Commonwealth felt that it was appropriate, given the subject matter, and as it would with anything pertaining to any grand jury, particularly what is purported to be an active grand jury presentation. The Commonwealth felt that the protective order impoundment was appropriate. Pursuant to the case law, I would ask that the motion be allowed.
All right, and just so we're clear, because you referenced it, I did receive, as you're all aware, correspondence from the U.S. Attorney's Office in Boston. We appreciate the opportunity to be heard, having reviewed all of the materials referenced above. The Department of Justice and the U.S. Attorney's Office for the District of Massachusetts do not object to public disclosure of the correspondence at issue in the pending motion. So with that, I'll hear from you now, Mr. Yannetti.
I appreciate that. Thank you, Your Honor. May it please the court. Your Honor, the Commonwealth seeks to suppress from public disclosure the contents of the 6 letters that were produced for the defense on December 4th of 2023, as well as the additional 2 letters that were produced on January 4th of 2024, which was the day before our last court appearance. I would suggest that it's ironic, however, that in order for this court to determine whether the drastic remedy of keeping those letters hidden from the public is warranted, the court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order,
just so it's clear, I have not seen those letters.
Okay. I still, Your Honor, I must discuss the content of those letters to some degree and argue to this court why a protective order makes no sense in this case. And with your permission, I'd like to divide my argument on this issue into 2 parts. First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case.
All right, so which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
So with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are.
Right. So I need them. I don't have them, and so you would be arguing the content of the letters in the first part. All right. How about the second part of your argument? Would you be arguing them as well? Nobody provided them to me.
Well, this is the Commonwealth's motion, Your Honor.
Yeah, and your opposition, and I don't have from anyone. So how about the second part of your argument, Mr. Yannetti?
Well, it does touch on that, Judge. You know, the Commonwealth has revealed some of the contents of some of the letters, but I need to point out what they haven't revealed. You know, and just so it's clear, I'm not going to be quoting the letters at length. I'm going to be talking about the subject matter of the letters. In my view, I don't know that the court needs to read the letters first, but I'll leave that to Your Honor.
All right, but you said you're going to reference them, and the whole motion concerns those letters. Do you have them, Mr. Lally? Do you have them with you?
Yes, Your Honor.
If you're just going to, in general terms, just give me a couple of minutes now to just look through them, Mr. Yannetti.
That's fine, Your Honor.
I want to go to this feed. This is from Canton. You can actually see Karen. You can see the courtroom, Yannetti in the corner, and Bev is looking over the documents right now. Much better feed.
So, Ms. Giannetti, so far there's one letter that I'm going to need more time on. It's a letter dated May 18th, 2023. The others so far, I'm prepared to let you argue in general terms.
With regard to that May 18th letter, Your Honor, that is not one that I will be quoting.
Okay, that's why I brought it up.
Right.
Okay, so
That's why I responded.
you also not going to reference the response to that letter? June 1st?
Correct. Yes. Yeah, those deal with the Office of Professional Responsibility. That was
Okay, I just have two more to just quickly take a look at.
Sure.
All right, so I'd also like some time to take a look at the June 21st and August 3rd letters. Were you planning on referencing them?
I'm going to reference them in terms of a subject matter, but not the details.
Can she not interrupt? Like she constantly I'm trying
So
to
the
not
letter dated August
on a
3rd,
table.
2023. You have that in front of you, Mr. Yannetti?
Do, Your Honor.
Interrupts.
All right, so the second paragraph, the second full paragraph, I'm not going to allow you to reference that right now.
Your Honor, if I may, the letter may be visible on the Zoom screen.
I've got the,
Just when you're holding it, you can see
see the light can see through it? Because I've got the print facing me.
You could see a portion of the print, that's all, just from the
Okay.
angle.
All right, thank you. All right, so with those parameters, Ms. Giannetti, I will let you reference the subject matter of the others.
Okay, that's fine, Your Honor. So in terms of the two parts of my argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cited Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. attorney to be taken off that federal investigation. And finally, category 3 is one letter from DA Morrissey to the new special agent in charge of the FBI, asking him to have his agents speak to the state police who are under DA Morrissey's command. To be clear, there is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the proper subject of a protective order. They should be unsealed forthwith. But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is, it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that, even before the U.S. attorney ever confirmed that there even was an investigation. And Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's Office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions. My client is entitled under the Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. So, Your Honor, because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right, is there a response from the Commonwealth or no?
No, Your Honor.
Okay, all right, so I'll take this under advisement. I do need copies of these letters, so if Mr. McDermott can
On
copies
the
and then
record.
hand them back to the Commonwealth.
On the
all right, so the
record.
second motion is the Commonwealth's motion for Rule 17 for records from Boston Magazine. And I understand there's counsel here from Boston Magazine. If you'd come forward, sir. Hi, you can stand at the podium or council table, wherever you're comfortable. In a minute, I'm going to ask you your name and I'm going to hear from you, but I do just want to state that I appreciate that today I did receive a response from Boston Magazine. I received there's a memorandum, there's a limited opposition, there's affidavit, there's a memo. I found all of this helpful. I did have the opportunity to read it a short time before the hearing, but I do appreciate the response, and more importantly, I appreciate you being here. So could you tell me your name, please, sir?
My name is Robert Birchie. I'm from the firm of Claris Law.
Could you spell your last name, please?
Last name is B like boy, E-R-T-S-C-H-E.
Okay. All right. Could you tell?
I'm MetroCorp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right. So there is the Commonwealth filed a Rule 17 motion. You, as the third party or the record holder, have a right to be heard. So I'll hear you.
Thank you, Your Honor. There are really three documents at issue, two recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely, on the record, were interviews with Ms. Reed in the presence of her counsel.
Okay, you say almost entirely on the record. Could you explain that, please?
I'm sorry. There are a few interjections by counsel, and there are also a few areas where counsel asked, or Ms. Reed asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third records?
The third is a interview with Karen Reed alone at her home between Gretchen Voss and Karen Reed that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Reed from that interview appear in the article.
Okay.
There's also a fourth category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed that were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
What just happened?
All right, thank you.
What the hell?
The argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2, because it really is just a fishing expedition. The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes.
Okay.
Counsel is present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Can you tell me about that?
I'd be happy to, Your Honor. And she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself and to her children. She has received inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
Okay.
And and she says, that these are, she's never experienced in her 25 years of reporting anything like this before. So if Your Honor is all right, I'd like to proceed to the Rule 17A2 argument.
Yes, please.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot. They've got a long, detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a gold mine, there must be more. And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Reed had confessed in her interview with Gretchen Voss, that would have made it into the article. This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained. And the extra that the Commonwealth asserts might be found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape. Body language, physical reaction to a question, the same thing. These being only audio tapes, they won't reveal that. And there are further arguments about Rule 17A2 in my papers. With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas. And that was in Re Pappas case, 358 Mass 613, the case that ultimately, when it went to the Supreme Court, became Brandsburg v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by too broad subpoenas, that's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas Court said it may be argued that use of newsmen as witnesses is likely to result in unnecessary or burdensome or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion. Underscoring that point, when the U.S. Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Brandsburg v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need, he will have access to the court on a motion to quash, and an appropriate protective order may be issued. There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 16 when considering a request to compel information from a reporter or a news organization. They went on in 1991 in the matter of the matter of John Doe grand jury investigation to say that this balancing requires balancing between A, the public interest in having every person's evidence against B, the public interest in the free flow of information which can be implicated by needless disclosure of sources or confidential information. In that case, Doe affirmed an order quashing a grand jury subpoena issued to a news reporter in a murder investigation where the information sought had, quote, according to the court, low likelihood of benefit to the grand jury when balanced against the public interest in the dissemination of information. That's Commonwealth against Doe, 410 Mass at 602. There's also the Commonwealth against Bowie case from 1995, affirming a trial court order quashing a subpoena issued to a reporter by defense counsel in a murder case. And those two cases, I'd say, are exactly on point. Now, here, Ms. Voss has to some extent performed her own balancing test. And after considerable discussion and consideration, she decided to waive her privilege as to the two recorded on-the-record interviews that took place where the lawyers were present, except for those sections that were lawyer colloquy or designated to be off the record. But she asserts the privilege firmly against production of the handwritten notes of an unrecorded, off-the-record interview outside the presence of counsel. I'd submit, Your Honor, that her notes of that third interview are unnecessary. She's not an eyewitness to any events in the case. She's provided a detailed article that provides a roadmap to Ms. Reed's statements and is set out in her affidavit. Production under these circumstances really does threaten legitimate interests. Some of those set out in the affidavit of Chris Vogel, the editor of Boston Magazine. Judicial intrusion into the news gathering process, the disadvantage of a journalist appearing to be a research tool of the government, the disincentive to the media to save notes and to interview outtakes if such can be casually compelled, and the burden on journalists' time and resources. And my client would attest to you that already the burden on time and money has been more than they care to bear, although they do understand that under normal circumstances, the Commonwealth is entitled to evidence when there are proper circumstances. All of these interests, along with the harassment campaign against the reporter, disincentivize the media from engaging in objective investigative reporting. So there's a principle that is at issue here, and it's the ability of the press to continue to perform their constitutionally recognized role as the fourth estate. Now, there's an additional argument on this, which is recently revised federal criminal guidance that supports the denial of the Commonwealth's request for the off-the-record interview notes or for any unpublished material. The petition for the promulgation of rules, 395 Mass at 172 in 1985, the Supreme Judicial Court said, in cases like this one, where the reporter has no personal knowledge of the events about which he is called to disclose information, it may be appropriate for the trial judge to consider the guidelines of the United States Department of Justice contained in the CFR. And the rule, as revised in 2002 from the Department of Justice, declares that, quote, the use of compulsory legal process to seek information from or records of non-consenting members of the news media constitutes an extraordinary means, not a standard investigatory practice. And it goes on to say that the department may not use compulsory process to obtain information from or records of a member of the news media, period. Now, I'm not saying that that is binding on this court, but it is, I think, persuasive from the nation's federal police authorities. So in conclusion, I ask that the court deny the Commonwealth's request as it pertains to the handwritten notes of the off-the-record interview and as it applies to the lawyer colloquy or off-the-record statements in the 2 audio-recorded interviews. Voss and Boston Magazine do not oppose if the court exercises its discretion to allow the remainder of those 2 taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
All right. So is Ms. Voss willing to still provide the 4-hour interview and the 2-hour interview that are on the record? She's still willing to provide those?
Willing to provide the recordings, yes.
Okay, and how long will it take for you to provide those to us?
Well, there will be some redaction needed. I'm not quite sure how that gets conducted, but within 2 weeks, possibly less if necessary.
All right. All right, I'll hear the Commonwealth and then I'll give you a chance to be heard again, sir, if you want.
Thank you.
All right, Mr. Lally.
Thank you, Your Honor. Your Honor, the nature or the chilling effect on news gathering that counsel alludes to in the motion in opposition as well as in argument, the Commonwealth would submit is speculative at best. I refer to the court to the decisions that are cited by counsel in the opposition as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases, but essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here, the source itself is not confidential. So we're not talking about a confidential source, we're talking about potentially confidential information. But notably, what's cited to our federal cases because there is no reporter privilege in the Commonwealth of Massachusetts. It doesn't exist. What I would submit based on the Commonwealth's motion and submissions that there's not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition. To cull through a vast array of relevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. For 2 of these 3 interviews, she's present with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant, makes them admissible. And that is why the Commonwealth is specifically requesting those particular items. As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these, has met its burden under Rule 17, and would ask that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss considering what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting, again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in those, not seeking those, not asking the court to order those in any way, shape, or form. And again, as it pertains to any of those items, the Commonwealth would suggest that in this case, I think an in-camera review by the court would be appropriate based on whatever is submitted, particularly as it pertains to that third. I don't think there's as much of a concern, and there's no real objection that I can surmise as to the first two recorded interviews. But as it pertains to the notes, I think an in-camera review would be appropriate.
What do you say about that, Mr. Bershon?
A couple of things, Your Honor, very briefly.
Sure.
I'm not sure that the Commonwealth heard what I said because Ms. Voss does not oppose the release of the two interviews, save the off-the-record portions of the lawyer.
I think he's talking about the third interview.
Yes, but I'd also refer to any part of the first two interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off-the-record portions contain, but if they contain statements by the defendant, the Commonwealth would be seeking those as well.
Well, that gets to the next point, really, the distinction between confidential sources and confidential information. And I'd submit that that's a distinction without a difference. The same.
But is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please feel free to provide it.
All right. Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I appreciate the way in which they narrowly put their subpoena in terms of only wanting statements of Ms. Reed and not of anyone else, not from counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize the common law privilege. They do. They recognize an evolving privilege that's really flexible enough to take in the particular facts of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C with particular rigor and on the criminal side as well. The question of harassment comes up as part of that test. And it's true. We're not saying that the Commonwealth has harassed Ms. Voss, but she has, in the unique circumstances of this case, suffered and will continue to suffer harassment to the extent that her role becomes large. And ultimately, Your Honor, there's a lot there, and we're not saying the Commonwealth is overreaching, and we're not saying that the Commonwealth is in bad faith, but we are saying that the Commonwealth is asking for too much.
Okay, thank you very much. So you say it'll take you 2 weeks to get those first two redacted and sent in.
Thank you very much.
And if you want to respond with at least that case, so I'll take 2 weeks then to decide this. So the sooner you can get me anything else you want to get me, I am concerned about the safety of the reporter. She shouldn't have to suffer harassment or any danger as a result of this.
Of course not, Your Honor.
All right.
Counsel, is February 1st, which is 2 weeks from today, is that doable?
That's doable.
Okay. All right. Thank you. So, Ms. Giannetti, we need to get a date for the remaining two motions that were filed by the defendant, the motion to dismiss and the motion to disqualify the district attorney's office and sanctions. All right, so as you probably know, we're in the middle of a trial that's going to go a few weeks. Jim, can you suggest a date?
I can. How about?
May I interject, Your Honor, with regard to a date? I know that our final pretrial is February 15. Our request will be
February 15th? I thought it was February 26th.
We have two.
Okay.
We have February 15th and February 26th.
Okay.
So you're both right.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15. I'll tell you why, Your Honor. One thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. Attorney, is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Giannetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we'd probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
I'm sorry, the 15th?
Yes.
That should be fine.
Jim, is that at 2 o'clock?
It is at 9 o'clock.
All right. Assuming we're not on trial, it'll be at 9 o'clock. If we're still on trial, it will be at 2.
That's fine.
Your Honor, the only issue there is that I do have a trial before Your Honor that's scheduled for February 13th. So,
right. That's the case that I expect we'll be on trial for. And if that's the case, we have to finish that. We've got a very busy trial schedule. So if we're on trial, we'll see you at 2 o'clock. All right. So stay in touch with Mr. McDermott. All right. Is that it for today then?
that's it for the Commonwealth. Thank you, Your Honor.
You all set, Mr. Yannetti?
Yes, Your Honor. Thank you.
Okay. All right. And Mr. Birchie, I appreciate you being here, sir. All right. Hearing's over. Jim?
Thank you.
Jim.
February 15th.
Okay.
That's it. I want to go back to, I just ate an apple way too fast. It's taken a long time to go down and it hurts. So bear with me for a second. I want to go back to when Yannetti was on fire talking about the federal investigation. So I'm going to go over to the court TV feed and replay that. I want to hear that again. Let me just go back. See if I can find it here. We got literally trolled by Joe Biden earlier. Unbelievable. Now, Kevin, be nice, Kevin. I've been very nice to you. And I actually said something very nice about you on stream the other night. So please don't come in my chat and try to start shit in here. I don't do that in your chat. I don't even watch your channel. And just don't come in here and disrupt mine. But if you're going to be a dick, I'll just bounce you out of here. I actually was really nice to you the other day. I said something actually really nice about you. I get it. We don't agree. You don't agree with the people that are in this chat. It's fine. Go talk about us on your channel. I've been very respectful towards you. You've slung a lot of shit in my direction, and I've been really respectful towards you. So please don't come in here and fuck my whole chat up. I'll just bounce you out.
In terms of the two,
the letter may be visible on the Zoom screen.
I've got the.
I think this is the part here.
See, the light can see through it because I've got the print facing me.
You could see a portion of the print, that's all, just from the
Okay.
angle.
All right, thank you. All right, so with that, with those parameters, Ms. Giannetti, I will let you reference the subject matter of the others.
okay, that's fine, Your Honor. So in terms of the two parts of my argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standard. In their motion, the Commonwealth cites Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation. And finally, category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI asking him to have his agents speak to the state police who are under DA Morrissey's command. To be clear, there is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal. There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the subject, not the proper subject of a protective order. They should be unsealed.
Listen, you know what? And listen, I've ignored all the shit slinging to me, and I know they, you know, and I tend to just let it go because they're in this business, because it is a business, in this business of online and exposing yourself and putting yourself out there, they're going to people that just don't like you, and they're going to come at you. And I get it. I mean, I can only imagine with someone like Turtle Boy that has 50,000 subscribers, the shit that must get slung on him. And I get it. He snaps back sometimes, but I'm trying to be fair to everybody. And I've always been very fair to everybody on both sides. If they want to come in and debate or whatever, or you know, talk about things that they might look at a different side of the case, and that's fine. Like, we see it our way, he sees it his way. But I don't want people to come in here and disrupt the chat. We're here for the specific purpose of why we're here. We know that Karen Read is innocent. That's why we're here. If you don't think that Karen Read's innocent, go do that on your10 That's fine. I don't go in, like, I've never been in his chat before. I would have never done any of the stuff that was just going on here 5-10 minutes ago. That's not my style. So to me, that's people like, I got to get some eyes on my channel. I got to get people over talking about me, like that kind of shit. you know, and it's just super disruptive. We're here to be positive. We're here to push this movement. I get it. You don't like it. Fine. You got a personal thing with me. Hit me up on Twitter. Email me. Let's talk, you know. But on my last stream that I had Tom on, I actually just recently found out because I started looking into Kevin and finding who he was. I didn't know he had cancer, and that's awful. I wouldn't want someone to go through that, and I feel bad for him. I actually said it's a horrible thing that he's going through that. Cancer touches everybody's life in some way. Either you or someone has it. I was very nice to him, but don't come in my chat, dude, and like disrespect people and shit. I get it. Like, it's fine. Do an opposing stream. Fucking be creative. Pull up the live feed and talk through it, just like we're doing, and say, you know, this can't be possible. The feds, this, and that, or no, the reporter is being harassed. Be creative, but don't come in here and disrupt like what we're doing. You know, I get it, dude. I'm a fair dude. I try to keep things on both sides. I'm a peacemaker, you know, but I don't do that, dude. I don't go in your chat and start that shit. And it's non-productive. But anyway, I'm going to move on from that. Thank you, Lee. Thank you so much. Appreciate all the work and streaming today. You know, it's just, you know, whatever, man. Just don't come in my chat. It's better that way. All right, let's go back because this is very important and I want to hear this a little bit better.
Motions, that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public.
I haven't slung one thing at Kevin.
That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the subject, not the proper subject of a protective order. They should be unsealed forthwith. But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this court, what good would that do? How effective would that be? The answer is, it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date. And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today.
I'm glad and you know, I love this. I'm glad that Yannetti got this on the record, and I'm glad that at the end of the hearing, he got it on the record again. That's very important. That's very, very important, because if or when this goes to trial, and I don't think it's going to, I think this in 2 or 3 weeks, Karen's going to walk out of that courtroom a free woman, and this is going to be over. But if it did go to trial, this is good all for the appeals process. I'm telling you. But I just think now, and Yannetti getting on the record that this is still an active investigation by the FBI. This is not something that, oh, they looked into it and here's a couple of pieces of paperwork of our reports. It's still ongoing. They're still looking into it. So that is on the record. It's on the record right now, and that's what we needed to hear today. So Yannetti went for it. I love it. Twice and reminded Auntie Bev that, listen, there is a federal investigation into this ongoing, and it's so good he got that on the record today. All right, let's keep
the specific content of those
Gary,
letters
thank you for the
is
10.
one of the grounds
Thank you.
that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters.
It was an amazing day for Karen Reed
that is
today.
the reason that our
Amazing
motion for
day for
sanctions is
Karen.
currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that even before before the U.S. Attorney ever confirmed that there even was an investigation. And Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday.
I got to do it.
It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck.
It's a duck.
Right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions. My client is entitled under the Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office.
Let's cut into Court
The letters
TV.
demonstrate that
I'm going to go to Court TV. They're reporting right now. Hang on.
Recorded interviews. Voss and Boston Magazine do not oppose if the court exercises its discretion.
Might be a little behind.
Allow the remainder of those 2 taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
All right.
Yeah, it's way behind. But let's
So
see if they have some
Voss
commentary
willing
afterwards.
to still provide the
Not too bad. I'm going to hang out
first
for a little while.
4-hour interview and the 2-hour interview that are on the record. She's
Let's
still
hang
willing
out.
to provide
What
those?
happened?
To provide the recordings, yes.
Okay, and how long will it take for you to provide those to us?
Well, there will be some redaction needed. I'm not quite sure how that gets conducted.
Okay.
But within 2 weeks, possibly less if necessary.
All right. All right, I'll hear the Commonwealth and then I'll give you a chance to be heard again, sir, if you want.
Thank you.
All right, Mr. Lally.
Thank you, Your Honor. Your Honor, the nature or the chilling effect on news gathering that counsel alludes to in the motion in opposition as well as in argument, the Commonwealth would submit is speculative at best. I would refer the court to the decisions that are cited by counsel in the opposition as well as sort of ancillary to those, the Brandsburg and the Jennings decisions as well. They're federal cases, but essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas the source itself is not confidential. So we're not talking about a confidential source, we're talking about potentially confidential information, but notably, what's cited to our federal cases, there is no reporter privilege. It doesn't exist. what I would submit based on the Commonwealth's motion and submissions that there's not a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth expedition. To cull through a vast array of irrelevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and they come typically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing, and it is obviously aware of that. For two of them with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defense that specifically pertain to this case makes them relevant, makes them admissible. And that is why the Commonwealth is specifically requesting those particular items. As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue the court as far as
I'm glad I didn't use that
whether or not any of the
TV
statements
stream.
are
It's
provided
terrible.
relevant. But the Commonwealth is entitled to these, has met its
I want to
burden
see if
under
they
Rule
commentate
17 and
after
would
this.
ask
I
that
want
the
to see if
motion be
they,
allowed.
they have any legal
So in
experts.
the balance test that the law says I have to
Almost
do,
over.
shouldn't consider the danger or
God, their feed's
personal
terrible.
risk to Ms. Voss, considering what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think case law also says that those types of concerns yield to a criminal prosecution in this case. And in part, again, just based on the limited specific scope of what the court is requesting, again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes, defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth is interested in those, not seeking those, not asking the court to order those in any way, shape, or form. As it pertains to any of those items, Commonwealth would suggest that in this case, I think a camera review by the court would be appropriate based on whatever is submitted, particularly as it pertains to that, sir. I don't think there's much of a concern, and there's no real objection I can surmise as to the first two reported interviews.
This feed's terrible.
I think an in-camera review would be appropriate.
What do you say about that, person?
A couple of things, Your Honor, very briefly.
Sure.
I'm not sure the Commonwealth, but I see opposed to the release of the two interviews, save the record portion.
This feed's terrible.
I think he's talking about the third interview.
Yes, but I'd also refer to any part of the first two interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off the record portions contain, but if they contain statements by the defendant, the Commonwealth would be seeking those as well.
Well, that gets to distinction between confidential sources and confidential information. And I'd submit that that's a distinction without a difference. The same.
Move the audio
Is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please feel free to provide it.
All right. Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I
appreciate the way in which they narrowly put their subpoena in terms of only wanting statements
I agree.
of Ms. Reed and not of anyone else, not from counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize a common law privilege. They do. They recognize an evolving privilege that's really flexible enough.
It's such a
to
good
take
day,
in,
Nick.
The particular facts
Right?
of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C with particular rigor, and on the criminal side as well. The question of harassment comes up as part of that test, and it's true. We're not saying that the Commonwealth has harassed Ms. Voss, but she.
And what we need to do to retain those amazing lawyers is there is a link at the top. If anybody can contribute, please consider contributing to Karen Reed's defense fund. I have the link pinned to the top of my chat. If you can just spare anything, $5, $10, $20, anything you can do to support her team and keep these lawyers, these amazing lawyers that she has, Jackson, Little, Yannetti, going, this team going, please consider donating to her today. She needs our help. She needs our help. I would appreciate it. All right, let me turn this back up.
So I'll take 2 weeks then to decide.
I want to see
So
if they're going to
the
do
sooner
any
you can get me
commentary at the
anything
end.
else
If
you wanna
not,
get me.
we'll
I am
bunk it
concerned
down.
about the safety of the reporter.
Funny.
She shouldn't have to suffer harassment.
She's concerned about the safety of the reporter, but not concerned about the federal investigation right now. Unbelievable.
Okay. All right, thank you. So, Mr. Yannetti, we need to get a date for
And keep in
the
mind,
remaining 2 motions
she's
that were
pushing
filed
to
by
make this
the
trial
defendant,
happen.
the
She's pushing to
motion
make this trial
dismiss
happen.
And the motion to disqualify the district attorney's office and sanctions. All right, so as you probably know, we're in the middle of a trial that's going to go a few weeks.
Thanks, Dave. I appreciate it. Thank you for the support.
Jim, can you suggest a date?
Jim.
May I interject, Your Honor, with
Here it
regard to
goes,
the-
Yannetti again.
I know that our final pretrial is February 15. Our request will
February
be that-
15th? I thought it was February 26th.
We have two.
Okay,
We have February 15th and February 26th.
okay.
So you're both right.
Well, that actually fits in with what I was going to ask, because our request would be for the motion to dismiss and the motion for sanctions to be heard on February 15. I'll tell you why, Your Honor. One thing that I did not mention regarding the phone call, the conference call that we had yesterday with the U.S. Attorney is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to
Did they
trial.
give you a date, Ms. Giannetti?
They did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we probably get this information sometime in early February, and I don't want to
Always cuts them off.
particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right, does that date work for the Commonwealth for that purpose?
I'm sorry, the 15th?
Yes.
That should be fine.
Jim, is that at 2 o'clock?
It is, it's at 9 o'clock.
All right, assuming we're not on trial, it'll be at 9 o'clock. If we're still on trial, it will be at 2.
The only issue there is that I do have a trial before Your Honor that's scheduled for February 13th. So
Right, that's the case that I expect we'll be on trial for. And if that's the case, we have to finish that. We've got a very busy trial schedule. So if we're on trial, we'll see you at 2 o'clock. All right, so stay in touch with Mr. McDermott. All right, is that it for today then?
That's it for the Commonwealth. Thank you.
You all
See if
set,
we have
Mr.
any-
Yannetti?
Yes, Your Honor, thank you.
Okay. All right, and Mr. Birchie, I appreciate you being here, sir.
There's a lot at stake, in my opinion, right, Michael? All right. So basically, the Commonwealth just argued, and I wrote down criminal justice outweighs the First Amendment in this case because they want any of the defendant's statements made to the reporter during the reporter's investigation and talking in notes. And generally, that is not something.
We're going to talk about a fucking reporter right now and not the fact that there's a federal investigation, an ongoing federal investigation. Hello, Court TV. Wake up.
In Massachusetts. I
Commonwealth.
find that hard to believe. They did argue, the reporter, the attorney for the paper did argue that it's an evolving privilege that would cover this situation. I certainly hope it does. We are lawyers, but first and foremost, at this point in our career, we're journalists, and I don't like the idea that the state would
about
want
the federal
or even be able to
investigation.
get, even if the statements were made during a pending case, if it's made to a reporter, I think that needs to be protected, because if you don't protect it, it's a chilling effect on our institutions of the reporters,
ironic.
newspapers,
They
television
protect it
stations,
for this
et cetera.
person,
think
but
it
don't
cracks the
protect it
door
for Turtle
open
Boy.
to
And
then
Turtle
try
Boy's
to
in jail now
access
because of
everything
reporting.
that's privileged and protected and can't be revealed. So this is a big decision for
It's
the
a big
judge to
decision.
make, and she admits
Could
that.
have
She's-
ramifications in Massachusetts for a long time.
I agree with you completely. Let's bring in, still joining us for this hour, criminal defense attorney Marie Pereira. Marie, what did you think as you were listening to these arguments, specifically about the reporter's notes?
What are you talking about?
I think it should be exempt, and I agree with
There's
Michael.
a federal
It could have a chilling
investigation
effect, because
ongoing
what
into
is
the
purpose of the word
investigation.
off the record if you can release the record or be forced to do it by the state or anyone else you wouldn't have wanted to hear it. That's why people say off the record, and it allows the reporter to gain more information regarding what they're investigating, and allowing them off the record notes access could have an extreme chilling effect, and it impairs the freedom of the press to protect its material, to protect its investigations. Off the record is off the record. Once you release it, then what is even the purpose of saying the phrase? It's going to make people want to zip it all the time. Off the record could become on the record. Nobody's going to talk.
Yeah, and they're trying to sort of separate it, Marie, with a couple of arguments. One, that confidential sources, they agree, are protected, but that's different from confidential information, which I don't agree with. Now, the attorney said he didn't have cases on the top of his head to support that, but he's hopefully going to be able to find a case or two. But also that she made these statements while she knew that there was an ongoing case. What do you make of those arguments?
If she said it was off the record, whether or not she made the statements while she knew there was an ongoing case, it shouldn't matter. Because if those words were exchanged, she meant it to mean this will not be on the record. You will not air it. It's off the record. So regardless of what was going on during the time, the exchange of information and wording between the two parties indicates what type of privacy did she, Miss Reed, expect that she would have when she was telling the reporter what she was telling the reporter. It doesn't make a difference. As long as they agreed, the two parties, that it was off the record, it should still be privileged information between reporter investigating and person who is investigated and telling their story.
But even if it's on the record, I don't think you should have to release your notes.
I agree, because I think there is, as Marie mentioned, there is that expectation of privacy.
Right.
Whether you're on the record or off, you believe that those conversations are protected, and they should be. All right, we'll see how that turns out. We're going to take a break right now. Marie, stand by. When we come back, Matt Johnson, our reporter out there, is going to join us live. He was out there live for the hearing. A lot going on in and around the hearing as well. A lot of supporters for Karen Reed out there, so we'll hear from him when we come back. Keep it here on Court TV, your front row seat to justice.
All right, we'll hang here for a little bit. I'm not going to go anywhere. Let's hang out. They better talk about the federal investigation. They need to talk about the federal gate. Like, hello, is anybody paying attention?
Case against Karen Reed.
Oh, Vinny will be
Plus,
on
the
tonight
latest
at 8 p.m.
developments in the Delphi
We'll come back and play
murder
Vinny
mystery.
tonight.
Will the judge continue to preside over this trial?
This guy is a complete mess. You went 2 times. You went 2 times. Yannetti on the record today. Yannetti on the record today says, Your Honor, there's an ongoing federal investigation. Hello, Your Honor, there's an ongoing federal investigation. And then that gets ignored. And then we start talking about a reporter. We're more concerned right now. And listen, I'm concerned for all reporters. I get it. I guess I'm a source of independent journalism. Okay. Yes, we have to protect our reporters too. But I would think today, the biggest thing that came up in court, we have an active federal investigation. And then we cut out to said experts on court TV, and they want to talk about notes being shared from a reporter and a reporter being harassed. I don't know what the fuck. It makes no sense to me. I think this is huge. I think that everybody in that courtroom today, Bev, Lally, everybody on that process in the Commonwealth side was shitting their pants today when Yannetti got up and said, there's an ongoing federal investigation, and we'll be getting much more information in that before our February 15th hearing. I think everybody was swimming in their pants today. The shit was deep, deep. There's going to be, you can guarantee you this, in the next, 4 weeks? In the next 4 weeks, there will be a lot of conversation between the Commonwealth and the feds. I guarantee you. And I'm telling you that, well, and that's why she's like, oh, when are you going to get the reports? Did you get the reports? Where are the reports? Let's see the reports. You got to keep in mind, she's pushing for trial. She wants this trial to happen. I don't think it's going to happen. I think by February 15th, this is going to be done and over with. I think it's going to be dismissed and done. I mean, if there's an ongoing federal investigation still pending and still being investigated, just like Yannetti said, every single day that we wake up and we move towards trial, this is continuing to be investigated by the feds. So, yeah, I mean, Dave's got it right. In 3 or 4 weeks from now, the feds will be all over Massachusetts. I completely agree. Completely agree. We'll wait here for Court TV come back. I want to see the next segment. But listen, I appreciate everybody coming in today, hanging out here on LTL True Crime. Pretty exciting stuff. We passed 15,000 subscribers today. I appreciate that. Huge milestone here. And we have so much work to continue to do. But good stuff. All good stuff. And we'll throw a little 15,000 celebration pretty soon. I got a nice prize I don't want to give away to a lucky subscriber or a member. But I do believe that this is a huge day in this case. Oh, yeah, it sucks. It sucks. TB in jail, it sucks. And but I'm sure he knows. He knows what's going on, and I'm sure he's doing some cheering today too. I mean, it's his hard work that has helped get all the truth out there and helped expose what's going on, the cover up, and in getting this news out there. But we'll hang here a couple more minutes. I want to see the next segment. Let's see. We'll hang out. I gotta do one of these.
It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck.
All right, we're back here live to Court TV. Let's see what they got to say.
Back in a Massachusetts courtroom this afternoon. Part of the kill or cover-up murder trial.
She's accused of second-degree murder in the death of her boyfriend, Boston police officer John O'Keefe.
Now, prosecutors allege that she hit him with her car and then left him to die in a snowbank after a night of drinking.
But Reed and her attorneys claim that other officers who were at the party are the ones who actually killed him, and that this is all a big cover-up. Here to break down everything from the hearing this afternoon, our own Court TV crime and justice correspondent Matt Johnson, who is there live in Boston, probably pretty chilly there in Boston. Matt, always great to see you. Tell us about what more we learned about the federal investigation into this case.
Right, the big headline, Judge Ashley and Michael, bombshell in the Boston area tonight after Karen Reed's defense attorneys opened with that communication that they had, that meeting just hours ago, and that the feds say that the DA's office, the Norfolk County District Attorney's office, is still under investigation as we speak. And they are going to be releasing some of their investigation into this case within the next couple of weeks. This is when they were discussing that motion to release communication between the DA and the feds. At issue right now is about 6 to 8 letters between the Norfolk County District Attorney's Office, the U.S. Attorney's Office for the District of Massachusetts, and the DOJ Office of Professional Responsibility. Now, the judge, at one point, she took time to read some of those letters that they want in evidence and then released. And she said that she's reserving her ruling on the matter. But again, we learned that the DA's office is officially under investigation. Take a listen.
Something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case, but it is ongoing. It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means.
Now, again, all of this still under advisement by the judge making no ruling on the matter today. She is considering whether or not she will release those letters and the contents thereof, or if they need to be redacted in any way. But we also learned that the federal agencies that are the other half of the letters, they don't oppose them being released whatsoever. So it'll be interesting to find out what she decides within the next upcoming weeks.
And Matt, at this particular hearing, a number of really important issues in front of the judge. They're going to decide some of the others or argue some of the others at a later date. But one of the other issues that came up, and what can you tell us about the state's motion to release the Boston Magazine reporter's notes? This one is very impactful, I would believe.
It's very impactful for a number of reasons that you discussed right before the commercial break. I was listening to you guys, and I was seated next to that reporter in the area that they had roped off for the media covering the case today. And she was just leaning in. She was taking deep breaths as the attorney made a case on her behalf. Remember, it's Gretchen Voss that works for Boston Magazine that did this report about a year ago. And what the prosecution is seeking is all of her notes and everything that was off the record that may be memorialized in her notebooks or on, recording devices. They want that released for the prosecution case. And she had that attorney from her outlet, Boston Magazine, talking about the fact that this is a fishing expedition, according to them. It falls under reporter privilege, should never be released in the first place, sets precedent. And the reporter has been harassed. And that was very impactful in that room. You could feel it. Take a listen.
And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Can you tell me about that?
I'd be happy to, Your Honor, and she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself and to her children. She has received inappropriate, shall we say, texts with photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes. She's never experienced in her 25 years of reporting anything like this.
And she confirmed with that statement with me. I was seated next to her. She was, again, her family has been impacted by this, her personal accounts and her phone. She's received threats, as is what she said through this attorney. And, no decision made on that at this point in time, but the judge did ask for more case law because that media attorney is adamant that reporters are protected under privilege here in the state of Massachusetts.
All right, Matt. Now, we know at the end of the hearing, we heard some of the hearings were scheduled for a later date. Tell us all about what's up next in this case.
All right, Judge Ashley. So what is up next is going to be super critical and very pivotal because at the last hearing, right before court shut down, the defense filed 2 motions, and those will be argued at the next court date, which is February 15th. So number 1 is going to be the motion to dismiss the case. We get that in every single trial that we cover, so we're going to talk about that. And also the motion to disqualify and sanction the district attorney. And the defense says what will be brought to light by the federal investigation and what's in those letters is the basis for them filing that motion to disqualify and sanction.
All right. Thank you so much, Matt Johnson. Always great to have you with us. Michael, I must just quickly say to you, I mentioned from my perspective, why doesn't the DA step aside, let somebody else prosecute this just to keep it clean and say we're not hiding anything?
Yeah, I think at the end of the day, they don't feel like they've done anything wrong. They feel like they're doing everything up above board. They don't want to give in to these allegations by the defense. And it sets a bad precedent. If you scream loud enough, if you get enough people out there protesting, we'll step away. I think they have to fight this.
Okay. We're going to see what happens in that case. Of course, we'll continue to bring you that coverage as those hearings continue. Coming up next, though, we're going to switch gears and head to Key West, Florida for the.
All right. Wow. What a day. What a day. I hope Karen is celebrating today because I think it's really good, what happened today. Yannetti getting it twice on the record, once at the beginning and then once to remind at the end of the hearing. Definitely something I want to go over and dissect. I'm going to bring that up tomorrow to Melanie Little. She'll be live on my channel tomorrow at 8:15 p.m. Eastern Standard Time. So that's definitely something I want to go over with her as well, so we can play through that and review it and just get an attorney's take on it because I am not an attorney, but I am not even close to being an attorney. But I love this stuff, and I love being here with all of you. And I have such love for this community. And today you all should be proud because if you were here on day 1 or you're someone that's just new coming into the movement and supporting Karen Read, you're doing your job. You're talking about this. You're getting it out there. You're informing people, and you're letting people know that Karen Read is innocent. And the truth is starting to come out. And we've had a lot of truth shakers out there. The big one at the top, Aiden Carney, Turtle Boy. He's the one that peeled all the onion layers back and started putting the truth out there. And it's nice to know that the feds are continuing this investigation. It's an ongoing investigation, like Yannetti said on the record today. It will continue to be an ongoing investigation. And I'm hoping here in the next couple of weeks, they will submit their reports and this can all go away for Karen and she can walk out of that courtroom a free woman and never have to deal with any of this again. But then the work doesn't stop there, my friends. Now we have to look at who did this and hold those people responsible. And we will get to that. We will get to that. So crazy case, ridiculously crazy case, and such a win today for Karen Read's team. And I'm sure they're all smiling and celebrating. And this is the momentum that team needed and what we needed. What we needed to hear today. And Yannetti went for it. I loved it. He just went for it. He said, fuck it. I know he was like, fuck it. I'm just going for it and get it out there. And it's just good to have that on the record. So all good stuff. All good stuff here. I'm going to head off here. I hate to drop 1,200 people, but I'm going to head off. I'm going to get some dinner and I'm going to, reach out to my contacts and see what they have to say and go from there and celebrate a little bit today because today is a good day. Maybe I'll come back later on tonight, maybe pop up with a later stream and kind of go over this hearing again today. But I definitely will be back tomorrow, 8 o'clock p.m. Eastern Standard Time with Melanie Little. I'll drop that link over here Again, if anybody wants to join in, go over, set your reminders now. We'll be live at 8. I'm not sure how long we're going to go, maybe an hour, hour and a half would be great. I'm going to have her go over today's hearing, that portion of Yannetti talking. I want to hear that with her and just get her take on that. And of course, I want to talk about the Coffindaffer segment because that was great. So listen, great day today here on LTL. I appreciate it. We hit 15,000 subscribers. I would have never thought. But the channel is growing. You guys are all amazing. The guys and ladies, sorry, I would say that. I just say guys in general, but you're all amazing. Thank you for being here. Thank you for making this happen. Please, before we leave, if you can, please go to the top link there. If you can donate anything to Karen's Defense Fund, I would appreciate it. Even a couple of bucks. It helps. It helps keep that fantastic team in that courtroom so we can continue to get things like this.
It makes absolutely no sense. That is the Commonwealth grasping at straws. If it walks like a duck and talks like a duck, it's a duck.
I love it. It's a duck. It is a duck. And I appreciate it. Thank you all so much for being here and going through the hearing with me today. Again, I hate to let all of you go, but I got to get something to eat. I'm starving. And I will talk to everybody soon. So, I got an action-packed weekend again. Like I said, Melanie Little tomorrow on my channel. Saturday night, I think I'm doing something again. I'm hosting on Turtle Boy's channel. We'll have something lined up there. And then Sunday, we'll be back for the Looking Back series. I'm going to have Tom back on, and we're going to go through some more of the previous court hearings and some of the reporting up to the current date. So thank you all for being here. Again, if you're just first time over here, make sure to subscribe, like, share. We're currently at 732 likes. I love it. If we can get it to 1,000, that would be amazing. Smash that like button on the way out. Everybody go get something to eat, drink, celebrate a little bit, and enjoy. It was a really great day. And listen, all those people that were out at court today for the Canton 9, you're all amazing. Tom did some great streaming out there, and it makes a difference. Will had his own reporting today. The Glare was streaming a couple of streams today. He went over Aiden's testimony from last night. Great job on that, buddy. Keep going. We're all in this together. Let's stick together and keep the Karen Read movement going. I'm going to play the long outro on the way out, and let's do this. Turtles, hearts, and ducks on the way out. I want to see them. I'm going to open up the chat. Turtles, hearts, and ducks. Let's see it. Chat's going to open up here in a second. I love it. Boom. Chat is wide open. Turtles, hearts, and ducks. We got this. And I'm going to play the long outro today. All right. I'll see you all later, possibly in a few hours. I might pop up and do a stream so we can kind of go over this again. If not tomorrow, I'll definitely be here 8 p.m. Eastern Standard Time. All right. For Karen.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
And Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life. I tried to save his life at 6 in the morning. I was covered in his blood. I was the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question.
Yeah, LTL true crime, we going deep in the dark. Yeah, peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi. LTL true crime, unraveling the web of evil. No stone left unturned, we dive into the pond. Yeah, we digging up the dirt, bringing justice to the crime. LTL true crime, unveiling dark realities every time. Yeah, LTL true crime, we going deep in the dark. Peeling back the layers, expose the hidden mark. From the streets to the alleys where the secrets lie, getting into minds of the wicked, no alibi. Never get LTL true crime I go. Niggas can live in the shine, but then I'm not talking, baby, they get so. Look at the pussy new bone. No can you wait your life. Good now, you wait your love. We gotta hit that. You'll be hit that, hit that. Gotta do what he does. Hey, I think real true crime. I'm done with dark realities every time. This is yeah, I think real true crime. I'm done with dark realities every time. Yeah, LTL true crime.